live on the just a second. Okay, okay, we can start now.
We can start now, ma'am.
Yes.
A very good morning to one and all. In the beginning only, we pay a tribute to the Veer Jawans who lost their lives in the Kashmir. We, on the behalf of Internal Quality Assurance Cell, in association with Department for Promotion of Industry and Internal Trade, Government of India, welcome our respected Principal Dr. Geeta Menon Madam, today's guest speaker, Mr. Yogesh V. Bajaj Sir, Coordinator, National Intellectual Property Awareness Mission, Kuldeep Jangir Sir, our coordinator, Professor Neelam Kapoor, coordinator, Dr. Ajay Sir, organizing team, our head of the departments and faculty members of different departments, and our dear students in the webinar on intellectual property rights. We all know that we are celebrating the 75th year of independence. Efforts are taken by all the stakeholders for this celebration. You must have all noticed a program Swarna Swar Bharat on television also. In this view, different departments of governments have also taken initiative. This program of intellectual property rights awareness is one of them under the umbrella of Azadi Ka Amrit Mahotsav. Now, I invite Program Coordinator and IQSC Coordinator, Dr. Ajay Singh Sir, to address the gathering.
Thank you, ma'am. Am I audible, ma'am?
Yes, yes, sir.
Yes.
Okay, so Honorable Principal, Dr. Geeta S. Menon, R.K.Talreja College, Ulhasnagar. Our resource person, Sri Yogesh V. Bajaj, Assistant Controller of Patent and Design. Our coordinator and NIPAM officer, Sri Kuldeep Jangir, examiner of patent and design, Patent Office Mumbai. Co-coordinator of the program, Professor Neelam Kapoor, convener, website and technical committee. Our committee members in the program, teacher participants, and dear students. Today's program is on the awareness about the patents, about the intellectual property right. So we know today IPR, how much it is important for all of us as teacher, for students also. Because every time we do the researches, we try to publish them, but we don't go for the patents. So it is just an awareness program, and the aim of this program is to aware the students, the teachers who are doing their best in the field, but they are not very much aware about the patent, about the procedure of the patent, about the requirement, about the significance of their researches. So the main aim of this program is to aware the students as well as teachers. And for this program, we have our best partner, Patent Office Mumbai, because it is very much closely associated with the patent procedure. Means how can a person suppose wanting going to have the patent for certain things, so how can they go for filing, how can they do complete the procedure. So we have today Patent Office Mumbai in association with this patent office, we are having this program, and we are very much lucky in this term. Patent office has given the opportunity to us to have this kind of program for our students as well as for our teachers. So I hope this program would be very much beneficial for the teachers as well as for the students, and they will be very much aware about the researches, their applications, and after that their patentings. And one thing I will add here, every time we do the researches, we publish the papers in reputed journals on different platforms, but we don't try to get the patents. So our first aim would be the patents, then after publish, and then after flourish. So we can go via in this way: patent, publish, and flourish. So in this way, we can get a number of patents in our country, and we can do our best in that direction. So I thank you all for coming here and participating and making this program as a successful program. Thank you to all. Over to you.
Thank you, Ajay sir. Now I invite respected Kuldeep Jangir sir, examiner of patents and design, to say a few words.
Hello. Am I audible?
Yes, sir. Yes, sir. Please
Yes,
go
yes.
ahead.
Thank you. Thank you. Thank you. And thank you, ma'am, for inviting me for this session. And thank you, Bajaj sir, for as a resource person for this webinar. And thank you, team of the R.K.Talreja College, for giving this opportunity to organize this webinar in your college. And I hope the students will very well known about their intellectual property rights after the session. After the session, I think every student will know about what is the intellectual property and what are the rights associated with these properties. And without wasting any time, I'm handing over the session to the Bajaj sir. And hello, Bajaj sir, handing over to you session.
Hello.
Okay.
Wait a minute, sir. We have a sequence. We will invite him.
Achha, okay.
Thank you. Thank
Sorry.
you. Thank
Thank
you.
you.
Nita,
Thank you so
please
much.
take over.
Yes.
Professor Nita, you can take over.
Ma'am. Thank you so much, sir. Yes, ma'am. Yes, ma'am. Am I audible?
Yes.
Hello.
Yes, you are audible.
Hello.
Yes, you are audible.
Yes.
Your voice is not coming very.
Now,
Okay.
I request our respected principal, Madam Dr. Geeta Menon, to share her views.
Thank you, Dr. Neeta Madam. Am I audible?
Yes,
Yes.
ma'am. Yes, ma'am.
Yes.
Thank you. Good morning, one and all. As said by Neeta Madam, today, February 14th, we pay our tribute to our Veer Jawans. As well, my dear young students, today being the 14th of February, Valentine's Day, I want you to start loving patent. Please hear to our resource person and understand what patenting is. Seva Sadan's R.K.Talreja College of Art, Science and Commerce, again and again, are here to help the students to be aware of IPR. My dear students, patent, the word patent is always being in the media, highly controversial. काफी सारे खबरें छपी हुई थी, बासमती किसका है। Now my dear students, बासमती तो हम बचपन से खाते आ रहे हैं, हमारे बुजुर्ग भी खाते थे। तो बासमती चावल का पेटेंट कहाँ जाएगा, कौन करेगा और वो किस कंट्री का है? टर्मरिक, नीम, फॉर सिंपल एग्जांपल्स। ये तो कंट्रोवर्शियल हुई थी भी। और now what was the reason? Because as rightly said by Dr. Ajay Singh, we were ignorant about our rights, our patent rights. So our intellectual ideas or our intellectual rights, we lost them. Somebody else took the benefit of it. Now, keeping this in mind, at the central government level, Government of India, the initiative has been taken by the Department for Promotion of Industry and Internal Trade, Government of India, under the aegis of Azadi Ka Amrit Mahotsav celebration. We have collaborated with the department to make our young generation aware of the Indian patent rights. We want our generation to be being innovative. You be innovative and you can patent anything that you feel is your idea. I'm sure the speaker for the day we have amongst us, Mr. Yogesh V. Bajaj, Assistant Controller, Patent and Design, Indian Patent Office, Ministry of Commerce and Industry. Please understand, Ministry of Commerce and Industry. But that doesn't mean art students cannot patent. That doesn't mean science students cannot patent. Why it is commerce? Because patent can give you royalty. Patent can give you your recognition all across the globe. You can sell your patent and get good amount of money. Students, the safety pin that you use every day, is an idea which has come into the head of a person, and then we are using it every day. It is such a convenient thing, such a small thing, but वो idea भी patented है. So you can patent anything on this under this sky and make yourself a celebrity. I congratulate all the participants here, teachers and the students who are eager to know about the Indian patent rights and the various aspects. Copyrights है उसमें, there are various aspects about it. हाल ही में आपने सुना होगा कांजीवरम geographical rights के अंदर आया है, कांजीवरम है, या there was one more textile. So patenting, you can do it. I invite Mr. Yogesh Bajaj, the resource person. Sir, the participant is yours. I wish all the best to my team under Dr. Ajay Kumar Singh and the teacher colleagues. Also my technical team headed by Professor Neelam Kapoor Madam. All the best to all of you. Over to you, Neeta Madam. Thank you.
Thank you, ma'am. Principal Madam has explained the patent with everyday examples, and with this note, I request Dr. Ajay Singh sir to introduce our guest speaker, Mr. Yogesh Bajaj sir, for the proceeding.
Thank you, Neeta madam. I'm
Over to you, Ajay sir.
Yes.
Yes,
Thank
yes,
you,
sir.
ma'am.
Yes, sir.
So I'm very happy to introduce today's guest, Sri Yogesh V. Bajaj sir, who is presently Assistant Controller of Patents and Designs. Sri Yogesh V. Bajaj joined the Indian Patent Office in 2003 as Examiner of Patents and Designs, and started his journey for examination of patents applications related to the electronic field. He has worked in Patent Office Kolkata, Delhi, for period of 1 year each. Presently posted in Patent Office Mumbai, and he is working as Assistant Controller of Patents and Designs. He has done his Bachelor's of Electronics Engineering in year 1991 from Mumbai University. Further, in 2007, he has started, in 2007, he has passed out Bachelor's of Law from Mumbai University. Prior to 2003, he has worked in various private organizations in oil and gas field, real-time chromatographs. During his tenure in Patent Office since 2003 till date, he has given many lectures on examination of patent applications related to electronics, computer field to new examiners recruited in Indian Patent Office. His achievements have been acknowledged nationally in disposing patent applications related to electronics and computer field. So I will request Yogesh V. Bajaj sir, please start your lecture and over to you, sir.
Thank you, Dr. Ajay. I am audible?
Yes, sir, you are audible.
Okay. Thank you, Dr. Geeta Menon, sir, Madam, Dr. Neeta Gundawar, Professor Neelam Kapoor. Just to say you that this is the Azadi Ka Amrit Mahotsav, and then for 20 last awareness is very less in our Indian continent, I mean in our country about the intellectual property. We have our property, we protected by putting grills, and our physical property like flat and the land, we protect it. Similarly, this is also an property which is called as intellectual property. We have to protect it so that we can benefit out of this intellectual property. Now, not wasting much time, I will just start with the lecture itself. As rightly said by Dr. Geeta Menon, Madam, regarding Basmati, this was patented in 1997 by US one rice company, and then there was an opposition that Basmati word used in the title of the patent is objectionable, and the certain claims were objectionable. So after that, US government has to revoke the patent in USA. They have to remove the Basmati word from their patent. Now you will come to know after this. I hope you will come to know after this awareness program. We have lot of intellectual in our own country. We need to protect. We need to bring out from our own self our intellectual, so that we can have the protection and we can benefit out of it. See, there are patents, designs, trademarks, geographical indication, copyright, semiconductor integrated circuit layout and design. So there will be some few slides on patents, few slides on designs, few slides on trademarks. Similarly with GI, that is geographical indication, copyrights, and few slides will be on semiconductor. And at the end, there will be some video show so that you will have more awareness, and some questionnaires will be there for you to give simple questions answer to it. Now, I will directly go to the first topic, that is patents. You can see this slide. We have a laptop in front of in the slide. That laptop itself has many intellectual property inside it. You can see LED display. the configuration of LED display. That is the subject matter of patent. So you can apply for a display patent. Then the body of laptop, that is the how it looks like, that is design subject matter. The Apple sign on it is a logo, which is subject matter of a trademark. Then a user manual, how to operate this laptop, is subject matter of the copyright. Then layout, the IC inside it, integrated circuit inside it, its layout is subject matter of SICLD. This slide tells you about intellectual property rights. How this property is created? There is a brain, there are some resources, and there is a effort, labor. So some action has to be taken. Without action, you will not get any product. So you have to first have an idea in your brain, but then you should have resources also. So most of the resources are provided by the applicants. So the applicant, they put their name on the patent, they get assignment from the inventor, and then the applicant, on the name of the applicant, the patent goes. So although the brain is of inventor, his name is also included. Now, but some effort has to be taken so that a property is created. Just by creating property is not enough, you have to protect also. Now, after this protection, you can utilize and commercialize also. In this slide, if you see, once you utilize it, automatically you get protection. And the second thing is you exclude the others to use that property. What utilization is there? You can have for your own use. You can license it, like we license leave and license of our flat or land. We give it to some other person so that we get a rental income out of it. Similarly, in patent also, you can license. In trademark also, you can apply for a trademark which is your idea, and then you can license it. So, or you can have it for your own use, franchise it. You can use that trademark and franchise it. Like McDonald's, they just give franchise McD, the logo of M, and then they earn a lot of money out of it. Merchandise, like a Disney word, the Disney logo, once you print on T-shirt or a cap, you have to pay royalty to that Disney company. Businessmen, they use this patent system or the intellectual property system to commercialize it, to increase their brand value, to earn. And academicians like us, we feel pride by putting our name in the patent. And then that is the advantage for the academicians. Now patents. What is patent? It's a grant by a sovereign state like country, India. It grants, it's a territorial grant. Once you apply in India, you get patent only for India. You have to go for other countries, then you have to apply there also. The same matter you can apply there in other country. So patent is nothing but given by a sovereign state. It is just to a person who, to exclusively stop others making and using it and or exercising or importing it. An invention for a limited period of time. So this is for 20 years. Patent is given for 20 years. What is in exchange that inventor has to give? He has to disclose his patent specification. But that patent specification should be written in such a way that every skilled person can reproduce the invention. If he cannot write it properly, and if an average person after reading it cannot reproduce it, then that specification is of no use. So once that all objections are met in the specification, then only the patent is granted to that person. And what it gives, it right to exclude others from using the invention. Owner has a qualified right to use the invention. These are the few scientists who have patent in their name, invention in their name. In British India time, you can see the Pankha pulling machine in Calcutta. Mr. George Alfred Depening, he, although a civil engineer, he was granted exclusive privilege for this Pankha pulling machine. Already, you know, this Pankha pulling machine we in India were using age old, some thousands of years back. But he, Mr. George, he had made some automatic arrangement or mechanical automation inside it, and he had made the efficient machine in this Pankha pulling. Then similarly, Thomas Alva Edison is known for phonography. Alexander Graham Bell is known for telephones. Wright brothers are known for aeroplane. Louis Pasteur for rabies vaccine. Alexander Fleming for penicillin. These scientists are few inventors who have invented these inventions which are in their name. Dr. Ajay, this screen you can see, no?
Yes, sir. Yes, sir. It is visible.
Yes, yes, yes. So this screen you can see is of a nano car. Nano car is having thousands of patents inside it, thousands of trademarks inside it. One product can have many different technology, different patent for that. So front view, the view itself is a design subject matter. The color combinations and the color pattern or the configurations, these are also matter of design and trademark. So one product can have many intellectual property inside it. Similarly, you can see hepatitis vaccine, which is also an vaccine which is at a low cost we are producing in India. You know, any vaccines in India are produced, 80% of vaccines of the whole world are produced in India itself. So you should be proud of all this. Jaipur foot is a prosthetic for the disabled persons. We have got it patented in India. These are the few diagrams you can see. Baby shower, then mobile embedded on your hand. These are the futuristic inventions you can find once they come out. These are all subject matter of patent, design, trademark. You have a drone seen over your mobile where you can swipe the card. Patenting is nothing but there are two major things. That is, one is formal examination, that is the application filing, procedural matters. Any law is having two parts, procedure matter plus substantive matter. In this, procedure is very important in patent and other trademarks and GIs also. Procedures you have to follow. If you are missing any timelines, then you, although you are very intellectual, you have applied it correctly, technically, everything is good. But if you are lacking in procedure, then you will not be able to gain your patent protection. So you have to be very careful while filing the application. Now you can see Form 1 is the detail of the application you have to give. Fees need to be paid with Form 1. Form 2, this is a technical thing. Details of invention has to be given in the sequence as I have written here. Title, background of invention, particular of drawing, brief description of drawing, brief description of the invention, that is summary of invention. Then the claims and the abstract and drawings. Fees are not required for 30 pages and 10 claims. If they are more than that, then accordingly fee schedule is there in our Patent Act, that according to that you have to pay the fees for extra pages. Then Form 3 is the details. If you are filing outside India, then you have to give details. Then Form 5, declaration. Who was the inventor in that invention? That declaration has to be given. Now Form 18 is the form which tells you that you have to apply for request for examination. Unless you apply for request for examination, although you have filed Form 1, Form 2, everything, but unless and until within 48 months, you don't apply for request for examination, your examination will not take place, and then it will be deemed withdrawn after 48 months. These are the fee structure for a natural person, startup entity, or a small entity, or educational institute like say Southern R.K.Talreja. They can apply for by paying 1,600 rupees for patent application for 30 pages and 10 claims. And then for request for examination, for Form 18 has to be filed for 4,000. So minimum 5,600 you have to pay for application. Now these educational institutes, earlier it was only government institute, but recently in Rule 2 2021, we have included all education institute which are recognized by UGC. They can apply with these fees. Otherwise, it was 4-5 times more, like 8,000 and 20,000 for request. So now for a natural person or a small entity or education institute, they can apply with these fees, minimum fees. Filing procedure. You can apply directly by post or by online also. Now, online, it is compulsory for the agents to, applicant can apply directly also, but either by physically or online. But for a patent agent, if you are hiring a patent agent, then he has to file it online only. This is the online portal in our ipindia.nic.in website. If you see, you will get this online portal seen like that. And there is a guidelines also given. If you click that guidelines, you will come to know how you have to procure your digital signature and how you have to log in into it. Expedited examination is a feature which was introduced in 2016. The rules had come for startup and small entity. If they are of this category, the applicant is of this category, they were allowed for expedited, because we have a lot of backlog in our office. So that is why we have introduced this feature, because the people who are very young and they are starting their startup projects and other companies, they should be expedited in their career. So the expedited examination takes place in our office for a startup entity, from MSME, small entity. Nowadays, we have introduced for a female applicant, if they are a joint applicant and out of that one is female, then also they are eligible for expedited examination. And earlier it was for Department of Government and government establishments. For them also, we have started giving expedited examination. And then if you are filing outside India through PCT route, but taking as India as ISA and IPA, that is Indian Search Authority and Indian International Preliminary Examination Authority. If you are selecting India for this, then also you are eligible for expedited examination in India. An agreement between Indian Patent Office and any other country. Currently, we have an agreement with Japan Patent Office. So the few applications which are coming through that route, then we, between India and Japan applications, we expedite. They are also eligible for expedite examination. Now, how do we process application in India here? So once it is filed, ordinary application is filed, a provisional specification has to be given to Indian Patent Office. So for after 12 months, you can file a complete specification by writing claims inside your provisional, then it becomes a complete. And after 18 months, we get it published. Once it is published, people in India or outside India also, they come to know that some invention is got published. So if we want to oppose after publication, there are 6 months for opposition also. Once it is published, it is coming for examination. In examination, we will examine the substantive part, formal part of it, and then the substantive part. And within 6 months, the objections has to be removed by the applicant by giving the reply. Well, if it is not done within 6 months, he can take extension of 3 more months. So total 9 months, and then he can file the reply. But if suppose he is not satisfied with the examination that he wants to contest, then he would be given a hearing by the controller, and then after oral hearing will take. If the objections are waived off, then it will be granted. If no, then it will be refused by giving sufficient reasons. Here in India, we have applications. If your application comes in, we first check for we first check for the security concern. If the application is related to Defense of India, we will send it to DRDO, that is Defense Research Organization, which will screen it for defense purpose, or if it is related to atomic energy, your invention, then we will send it to Department of Atomic. And once it gets clear from there, then it will be taken for examination. Otherwise, these applications will not be getting published unless they are getting clearance from respective departments. So as I told you, it's earlier in flowchart. This screen shows the same thing. Formal and technical examination, gist of objection is communicated, check the reply, re-examine, remove the objection, or have a technical discussion with the inventor or the applicant, and then decision is to be given. So what we do in technical examination, we read, understand the invention, and with respect to drawing, then we search for the citations, publications on worldwide database. Whatever you have applied, we will check it whether it was already copied, is it already copied, or it's a new thing. So after the certain assessment for novelty, inventive step, and industrial applicability with respect to the citations. So once the citations are, we are satisfied that the citations which we in our database are not same as what you have applied for. So we will dispose of it with grant application. We will grant it. But if the citations are same, then we will object it, and then we will give the citation to you so that you can compare and you can reply to it. As I told you, timelines are very important. Provisional to complete it is 12 months. For request, it is within 48 months. Reply to FER is 6 months. Then Form 3 within 6 months you have to file. Form 5 within a month of first filing. Withdrawal of application, if you want to withdraw in between, within 15 months you can do. Then hearing submission after hearing should be 15 days. Pre-grant. Before grant, anytime you can have a pre-grant. Any citizen can have a pre-grant after seeing the publication of the application. Post grant, after we grant the patent, then you have a 1 year time for post grant also. So you can see enforcement is in our inherent system. If you are not satisfied with the control decision after pre-grant, post grant, or after the grant also, you can directly go to the High Court also. Designs. So this is the second aspect of our intellectual property rights, that is designs. Design is the cheapest form say input. Very few money you have to spend on this. Design Act was in 2000, design rules 2001. So you have to understand design is nothing but configuration or a shape looked by the eye. It is judged solely by the eye, and it has nothing to do with the structural feature inside your product, but it should be only solely, as you can see the car shown here, the configuration, like the flower petals, what you can see, the green petal, this is a design, and the shape of the car, that is the design. So this protection you can take so that no one other can copy this color petals or this shape. So design means it's a feature of shape, configuration, pattern applied to an article. That is very important in design. It should be an applied article, not just by a diagram or 2D diagram. It should be applied to an article. Then only it will be considered for design. And it is judged solely by the eye. On the red lines you can see that are very important. And there are some disclaimer in this. Whatever written on this, any trademark written on this design application, that will not be getting protected with this design application. So these are some disclaimers. The term of design is 10 years, extendable to 15 years. Now, this is the legal definition of a design. Article means any article, partly natural, or includes any part of article capable of made and sold separately. So these are few legal terms and definition. Those who are in arts and LLB, they can also go through these legal terms. These are a few design examples which I have got. A sofa set, a cycle, a watch. So these are just, some people are very fond of just having that color combination in that product. So they go for that product only for the color combination. So this all matters when you sell anything. So when you manufacture any product, you should have your design protected. Set of articles are also protected in one single application. Like here, you can see teapot, tea saucer, and a teacup. These all three things or a tray. These all four things in one set, in one application, it is called a set of articles, and you can get protected. You can see the design over saucer and on the cup or on the teapot is same, like the format of the color combination of flowers on it or the drawing on it, they are all almost same. So this set itself in one application of design application, you can file the full set protection. Similarly, jewelry set can be protected in one application, that is set of articles, set of sofa. Filing, how is filing done? You can physically file in Delhi, Mumbai, Chennai, Kolkata. After digitization, we send it to Kolkata because design applications are processed only in Kolkata office. So technical examination takes place there and publication also takes place there, and all post grant registration, everything in Kolkata office. So for physical filing, you have to give DD in favor of controller of design payable at Kolkata only. For other IPR rights like patents, it should be payable at Mumbai or Delhi, wherever you are applying, that way. But if it is for whether you are filing in Delhi, Mumbai, Chennai or Kolkata, it should be written as Kolkata only for design application. Application fees. What are the application fee? 1,000 only for small entity, for an individual, for a startup or for education institute, and 4,000 for companies. And what you have to give all the detail, bibliographic data like applicant name, nationality, address, other things. Then it's class. In design, we have a class number for each articles. So that you have to give name of the article. And then 2 set of drawings you have to give. Power of authority if you are applying through an advocate or attorney. Assignment document, if it is assigned from a person who has designed to an applicant, then assignment document. Then form 24 if applicant is a small entity or a startup. This is the diagram which you have to apply. This is for a simple specification, you can say, for a design application. What it looks like, you have to give name of the applicant, you have to give the drawing of that, front view of that, top view or a front view, total number of sheet and the sheet numbers you have to mention. Then, and you have to write a single line in that. The novelty resides in shape and configuration of the title of your design, that is teapot here. So just by writing this much is your design application. And this 2 disclaimer you have to give, that no claim is made by virtue for registration in this, that is any mechanical or any other configuration, no claim is made by virtue. So this disclaimer is that if you are getting protection for a design, there is no structural, if you say that it is very good in handling and all that, that features are not protected by this, because these are patent subject matter, the brittleness and other things. So these mechanical things, arrangements inside it are patent subject matter, but only look, yes, it is a design subject matter. Then further, any trademark, if you write some name on this teapot, what it is there, if you write some Babool teapot name, that Babool will not be protected inside it, because that is a name. Name has to be registered in trademark. So this is the 2 disclaimer you have to write for each and every design application. First line is for your application, what you are want to protect. The second 2 are for disclaimers, and just sign it. That is your application. And then we will give you a certificate as shown here, the certificate of registration of design. You have a design number inside it, then the title of it, and the address of it, and the company name who has applied to it. This is the publication we do. As I told you, for each and every application, we publish it. In this publication, we give the design number, in which class it is applied, who has applied, date of registration, and the title, and the drawing we publish. Showing your IP is protected. How you will, once you get this design certificate, how you will protect it? By just writing registered or REGD on your article. RD also will be also do. If it is written RD registered, then it tells others that this article is a registered article. So he will not copy it more. So, or he will not reproduce more. And then there are certain textile goods and brittle goods like glass items in which you cannot emboss this registered or RGD word on it. So for them, there is an exception. Just registration certificate is enough to fight for the infringement. What is important timeline? As I told you, every protection has a timelines in this 6 months, which can be extended to 3 months for your first objection report. Term of design is for 10 years, extendable to 5 years. Request for initial renewal should be before 10 years filing. And the request for restoration, if it is restoration within 1 year, you have to restore it. If someone forgets to renew it, then he wants to restore it, then within a year after that, he can restore it. Trademarks. Now we will come to our third part of it. What is a trademark? Is a word, name, symbol, or a device, or a combination of that, like a Tata word, or Bata, or a Godrej. This all, they have certain Godrej, you know, it is written slant in some slant type of font. So that font itself is their trademark. The word itself, the term Godrej itself is their trademark. So these are age-old trademarks which they are using for their trade. Now, if they produce any other product also, they have to, they can, if they put Godrej, so what we will come to know, oh, this product is of Godrej and we will buy it. So it's a brand value for them. Now, what it does, it identifies, distinguishes the source of the goods. So source or the from whom it is produced. We will not go into detail where is the company or what it is, how it is preparing, what it can be the quality. The name itself suggests the quality and the manufacturing institute who is manufacturing. So the name itself suggests. Then what does it provides? It provides exclusive monopoly over class of goods. Allows the business entity to build public goodwill. Identifies the source, assures customer of its quality. So these are few trademarks. As I told you, MACD, Coca-Cola, Google, Adidas, Nike, Naukri.com, Ye Dil Mange Mo, Pepsi, Columbia. These are all trademarks. Their trademark consists of service marks also, trade names, collective marks, certification marks, taglines, slogans. Some advertisement you will see taglines and slogan that also are trademarks. Shapes, any shape, if you this shape of M, how it is written, that is also a trademark. Sound marks. Now, when you open your Windows in Microsoft Windows, there is certain sound coming out of it. So that sound marks are also protected by a trademark. What does a good trademark should have? It should be distinctive and it should not be deceptively similar. Now, suppose if I give you an example, Tata wants to produce shoes now, and he puts Tata on the shoe and he sells. He will not be allowed that trademark for the shoe. Why? Because you know Bata is similar to Tata, so he will not be allowed because we know age-old Bata is having a trademark for that shoe. So Tata cannot sell. We will not give any trademark to Tata for shoe. It is advisable to have a search conducted and evaluated. It also avoids unnecessary litigation. Now, how to indicate? As in registered design, we indicate RD on it. Similarly, if it is just right, then you can write TM. If you apply for any trademark of your own, you can just start writing TM after application on the product itself. But once it is registered, you can start writing this circle R mark after registration. How to protect your trademark? Trademark registration is optional. It's not compulsory. However, registration has certain advantage. What is the advantage? You can file it in national, regional, or international level also. So that is the advantage. You can go global. Then initially it is registered for 10 years and then renewable for 10 more years. In case of non-use of non-renewal or no policy, trademark rights are lost. If you are not using it, they are lost. The existing, the existing trademarks is governed by this Act 1999 and 2017 rules. This is our website, ipindia.gov.in, for the further studies of yours. Now we will come to our fourth part, that is copyright. The copyright, it's a bundle of rights. Lot of rights include one copyright will have lot of rights. Like in a film, if you prepare a film, there are many rights into writer right is there, the broadcaster right, who will broadcast it, performers right, the actor who will perform its performance rights are included. So it is called as bundle of rights, and it is an automatic right. Once you create it, once you write a novel, it is yours. You cannot, you no need to file registration also, but registration has certain advantages. So it excludes, it's an exclusive right given to a creator of a original work of authorship. So you are the author of that work. If you do prepare, if you make a film, you are the author of that film. So that is way it goes. Allows the owner to choose the way he wants to copyright his works or to make available to the public, or it prevents unauthorized copying. So, but a fair use of the copyright is allowed. Like if you write some educational book and then someone have a student want to study it, so he can photocopy, that is fair use. And if he wants to commercialize it, he has to take permission of that copyright holder. Criteria for work to be copyrighted is it can be original, or it can be fixed. Some error may be there, he has fixed it. It can be for that also, or with minimum modification, some creativity, that also can be copyrighted. Now, features of copyright. These are the chapter 210. 1 second. Huh? There are chapter 2, 10 and chapter 8, which tells you about provisions related to Copyright Office and registration of copyright. Chapter 6, 4 and 10 tells you about statutory and compulsory licensing of copyright. The provisions related to rights of owner and the tenure is in chapter 4. These are for legal people who wants to go ahead, study. So broadcaster right, performance right are in chapter 8 in that chapter copyright book. Provisions related to infringement and remedies, chapter 11. Dr. Ajay, everything is okay, like you can hear and
yes sir, it is
yes,
okay sir, yes.
Okay. Literary works, this is under section 2O, you can go in detail. Artistic work, section 2C. Work, section 2H. Section 2P is musical works. Recording works is in section 2XX. Cinematographic film is 2F. Now, we have certain names for each and every creative authors. Like if he is author of a literary or dramatic work, he is called as author. If he is created a musical work, then he is called as music composer. If he is artistic, then he is called as artist. Then if it is photographer, then person who is taking the photograph, he is the author. Then cinematograph, film or a sound recording, he is called as producer. Then literary, dramatic or musical, the person who causes the work is the owner of that copyright. Copyright has two basic rights, like is economic rights and moral right. What is different between this? See, economic rights you can sell, you can use for yourself, you can give it for license to others. But the moral right of that author, if he has written certain book, and if someone is misusing that book and morally hurting that author, the other person is not allowed. If he has purchased the copyright from him also, still he is not allowed. Purchase in the sense, if he has got license from the original, if he is taken reference that this is the original copyright holder, but still the moral rights he cannot take away from that original author. So moral rights are not transferable, but the economic rights are transferable. This is under section 14, this is section 57. There are many rights, as I told you, bundle of rights: reproduction right, distribution right, right to create derivative works, right of communication to public, right of public performance. So one action, one work, one creativity, so many rights you can have for that. Right against distortion, right of recognition, and each right is a valuable right. You have money encashed for that. Term of protection. What is the term? Life of author plus 60 years for literary and dramatic and artistic works. And for cinematographic films and sound recording, it is 60 years from the publication. For broadcasting rights, it is 25 years. For performance right, it is 50 years. This, as there are procedures for other intellectual property, for this also it is under form 14 you have to apply. Then each application can be filed in Copyright Office by a person or by e-filing also, and payment can be done through online gateway or DD, or by directly filing in our office also. Prescribed fees. What are the fees for these works like literary, dramatic, artistic, musical? This application, it is 500 only. For artistic, it is 2000. For sound recording, it is 2000. Cinematography, it is 5000. This is the examination procedure. There are procedures for examination. Once you apply, formality check is done, waiting period, scrutiny is done. If there is no discrepancy, it is approved by the deputy registrar. And then if he says yes, then it is approved and given registration. If it is no, he will hear that and he will reject it. If there is discrepancy letter is issued. If there is no response, it will be abandoned. If there is a response, again, it will go to the deputy registrar and further process takes place. Now we have come to the last part of our, no, not the last, second last, semiconductor integrated circuits layout and design. This is in year 2000. We have an act for this. What is in this act? Any semiconductor layers, if we do some layout for which will form some transistor circuits, integrated circuit it will form. It is protected in SICLD Act only. So layout design comes inside this. The registration is for a period of 10 years because there are fast changing technology in gadgets are changing fast. Miniature of mobile device is fast, and then display devices are changing. So this act is very important for those protections for those devices. And what are the fee structure? LD1 is the form number for layout design. LD means layout design. One number form for 5,000 rupees. If there is notice of opposition, it is 500. So similarly, this all fee structure is there for layout design. This is a very good, as Dr. Menon also has told that GI, right? She has rightly replied on that Kanchipuram sale. We will find in this slides. There is one video. Dr. Ajay, you can hear this video.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
सॉरी
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने, एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So, can you hear me? Dr. Ajay?
Yes, yes, sir.
Yes,
Yes, sir.
audible.
Yes, sir.
Okay.
Yes, sir.
Okay, so the GI, as you have seen the video, in that there are many GIs given. GI is applied only with the association of that geographical location from where the GI comes. So it is not for the individual to apply. It is for the association or the union of that place, farmers union, they can apply for the GI. What it is, it indicates that identifies a product that have a specific geographic origin. Geographic origin should be attached with that product, and it should possess a quality or a reputation that are due to that origin. Now, I will give you one example. Ratlam Save. Ratlam Save is prepared by the water flowing in that Ratlam city, and the spices used are in certain combination. So the geographic location water, the water content in that, it has certain minerals or some taste. If you prepare duff of that, say in Bombay, and you prepare, you will not get the same taste. But if you prepare it from the products from that place, the gram flour, the gram which is used, the flour which is used, or the water which is used, or the specific spices used, those are from that place, and that's why that origin, geographic origin attached with that Ratlamik seal, and it is having given a geographical indication. GI is given to Ratlamik. Similarly, Darjeeling tea. In Maharashtra also, we have Nasik grapes, Nagpur oranges, Kolhapuri chappals, Puneri topi. So there are many such examples. As you have seen, 300 or more GIs are given. Then Makrana marble. Then you have this Madurai Nali Nilgiri tea. You can see on this chart. Darjeeling tea, Makrana marble, Ratlamik silk, Kanchipuram silk. Katputlis of Rajasthan, Madhya Pradesh Madhubani painting, Bengal Patachitra, Cherial paintings, Burdry ware, Warli paintings, Magai pan, then Appamedi mangoes, Kashmir saffron, Shahi lychee of Bihar, Kurg oranges. So IP is everywhere. This is a small video which you go. So IP is everywhere. As you were seeing, the boy was walking around, and then in the store there are many products seen to him, and then each product is having certain protection. So that was the video of it. Patent is for 20 years, design is for 10 plus 5 years, extendable. Trademark is for initially 10 years and then extended indefinitely, subject to renewal every 10 years. GI is indefinitely, initially for 10 years, then subject to renewal. Copyright, as I have already told you, it is 60 plus authors term of life, and then for other works it is different, like broadcaster right is 25 years. Who can apply for GI? It is a association. That's what I would say. All IP rights are territorial in nature. First you have to protect and then publish. So just to protect, you apply and you are protected. Well, if it is granted, then you are protected from the day when you have applied. Then the rights are territorial in nature. Registration is done by the sovereign authority, like the governments. rights for limited period of time, no automatic relief. You have to go to the court by yourself if there is any disputes. Renewal fees has to be paid for some IPRs, for some it is not. Appointment of patent agent is not compulsory. Applicant can file directly by himself, except copyright and trademarks. Career opportunity for students. You can apply for examiners of patents and design if you have a engineering background or a science MSc graduation, or you can apply for examiner of trademark and GI if you have a law background, and for examiner of copyright, graduates are enough. Then other patent agents, if they are not successful in government job, they can become patent agent, trademark agent. Research fellow persons can work if they have a knowledge of other patent, trademarks and IPR rights. It is useful for research fellowship. Then patent litigation, for lawyers it is having a lot of opportunity, because once your protection is there, there will be litigation, and then for litigation lawyers are there always. Now, whatever I have told you, it is available, everything in our ipindia.gov.in website. And we have an institute in Nagpur. Its address and phone number is mentioned here. That is also available, its email ID, everything, details are available in our website, ipindia.gov.in. This is the page for that. And there are certain courses for trademarks, exclusive patent course, exclusive trademark course, or a combination course. You can go through every week. They have different schedules of workshops over there. Some quiz we will run through. This is a box having certain words, letters on it. So you can see some trademark written on it. If anyone can tell me.
Sir, one Bata.
Amul.
Right.
Amol.
Correct.
Students, you can write in the chat. Students can write in the chat. Bata.
Correct. So
remaining students should write. Write in the chat box. Alex. Britannia.
Correct. Okay, I will show it. It's Pepsi over here, then Link, and then you have a Cadbury, Amul, Tata, Horlicks, Babool, Bata, Dettol, Lux. Okay. Now next, you have some diagrams here, and find IP in number 1. What it can be, IP can be there for that painting.
Students, please write on the chat box.
Mona Lisa painting, you can see in a museum in France, this painting. So what can be a IP right on it? Type of IP, right? Are there any replies?
I will check, sir. Artist, someone has written artist.
Yeah, copyright for 1. For 2, it is design protection you can take. For 3, it is patents, design, trademark, and copyright also in that. For 4, it is trademark only, Bisleri. Then for 5, it is design and trademark. Now, which type of IP protects the painting painted by the artist?
Fast, write down.
Just now I have shown you one painting. What type of IP rights?
Design. Yeah, design. See.
No, it's
someone has written design, copyright.
It's copyright.
Patent, someone has written.
No, wrong. Copyright is the correct answer.
It is copyright, which is the right answer.
So second question is, what protects the IP created by a fashion designer?
Design, someone has written.
Right, that's right. Correct answer is design. What protects the advanced disk trick for the bike developed by the inventor?
Patent. Someone has answered.
Correct.
Patent. Many have.
Which
answered.
of this is a GI? Out of this, which is a GI subject matter?
Fast. Write down which is GI. Nagpur Orange.
Correct.
Shubham has written.
It's correct, yes. What does a trademark protect? Does it protect invention? Does it protect work of art?
Logo.
Correct.
Everyone is saying logo.
Right, correct. How long a patent lasts?
10. Abhishek Pandey.
20 years it is. Patent is for 20 years. If you have an original story, what type of IP rights to decide who can make and sell copies of your work? That story, what you have written, which type of copyright is designated for that? What copyright you will take?
Shubham Gupta copyright.
Correct. Imagine you are a
copyright.
cricketer. You are a cricketer and you want to sell a range of clothes. What type of IP you use to show that clothes are made by your company? You have put some cricketer type of things on your clothes and you want to sell that clothes.
2 answers trademark, 3 and trademarks.
Yeah,
everyone is writing.
Correct is trademarks, yes. So that's all. Thanks for listening. And thank you, Seva Sadan R.K.T. College, for patiently listening, and to all students also. Thanks a lot.
Thank you, sir. Just a request to all the participants, teachers as well as students, please fill the feedback form. Anita madam, you can take over.
Yes.
You can ask any question if you have.
Yeah.
Thank you so much, sir. You explained not so much known topic to us step by step very effectively, which included meaning, process, and many other aspects. Videos were very creative. Thank you so much for detailed informative session. Now I request participants, if anyone is having the question, please raise the hands.
Hello, Nita ma'am, can I ask the question?
Yes, ma'am. Please go ahead.
So my question to you is, normally educational institutions have the ability of idea generation. There is no doubt about it. But for that, I think we need some innovation drop boxes, etc., to be created within the campus. Can be generated through the hackathons or annual events, etc., competitions being conducted in the college. That is my first part. And second part is, sooner or later, IPR will be mandatory to each and every institution. And the government also has insisted on 1% of the budget for supporting startups, 1% of the entire budget for supporting startups. That's mandatory. Because if students or anybody has to come up with startups, you need funding. You can't expect the student to fund his own startup directly. So is that mandatory?
First question, what you said that you want to create a hackathon or
I said for innovation or innovative ideas, you need innovation drop boxes to be established in the institute within the campus.
Yeah, there is no such guidelines. You can do as your wish, like what you want to do. Awareness can be increased in any form. And then you can have Dropbox, it's innovative idea. Yes, you can do that also. Or you can have a session and then just hackathon type of thing in a conference, and it's up to you. You can do the whatever like you want, and then some innovation will come out, and then yes, it should be acknowledged, and they can go through the filing procedures as I have shown you, and then apply accordingly. So you can have one person who will guide them and then file it. Yes, sure.
And what about the budget part of it?
Second question, budget, it's not, a startup is given to a person that certificate only if he wants to commercialize it in a very big way. As I can tell you about electronics, Ministry of Electronic and Information gives 15 lakhs for any proposal. If you go to Ministry of Electronic, 15 lakhs for patent filing or any IPR filing, they have a budget of 15 lakhs for one person. So that is the budget given. And there are many NGOs also, or innovation institutes who funds it for innovation startups and other institutes. So you have to go through the websites for finding out who are funding it. So our patent office, we have just introduced that we will take less fees, that is 1/5 of the fees. From our side, it is that much that you have to pay 1/5 of the fees for the protection what you want. For all type of protection, IP, patent, trademark and design. But for funding part, you have to go to different subject. Like if you're electronic invention, you go to Ministry of Electronic. In that website, you will get how to get funded. Correct?
Thank you, sir.
Yes.
Anyone else wants to raise the hand, please? Go ahead. Okay.
There are many innovation foundations also who are funding for any innovation. So if you write to them, they will fund also.
Anyone else wants to raise the hand? Okay, thank you so much. I request Sangeeta Mankani madam to extend the official vote of thanks.
Thank you, madam.
Yeah.
On behalf of R.K.Talreja College, our accuracy cell and Department for Promotion of Industry and Internal Trade, Government of India, I sincerely thanks Mr. Yogesh P. Bajaj sir for giving us such important and valuable information about the patent. So your GIS have given us a different name. Till today it was G. Today we are learning GIS. Thank you so much, sir, and such a lovely presentation. We were not even allowed to do look here and there for 1 second. And the quizzes made us realize that the students were equally participating and listening throughout the session. Thank you so much for such a lovely session, sir. I thank you. I thanks the examiner of patent and design DIPAM officer, Mr. Kuldeep Jahangir, sir, for giving us opportunity to our college for organizing such an important webinar. I thank our principal, Dr. Geeta Menon, ma'am, for always enthusiastically supporting and selecting the different wide variety of informative webinars. I thank accuracy coordinator and coordinator of this webinar for Dr. Ajay Singh for organizing today's webinar. I thank Professor Neelam Kapoor, madam, co-coordinator and today's webinar, and the convener of Technical Support Committee, HOD Physics Department, for her valuable digital support for today's webinar. I thank all teacher colleagues who have joined for today's webinars because their presence is a inspiration for other teachers and students. I thank technical support team who has sincerely worked. Now at the end, my dear student, I really thank all of you for attending such a important seminar, and you have increased your knowledge, and thank you all for giving all all the replies. I think there was bombardment of chat at the end while the quiz was happening. All the students were answering. They were eager to reply, and the try was also good. Thank you so much. Thank you so much. Thanks to all, and thank you once again, sir. Bajaj sir, really a very creative presentation and information. Thank you, sir.
Thank you.
Thank you, Bajaj sir, from the RKT family.
Thank you.
I again once request everyone to fill the feedback form.